Now, like every time that I do a movie, like the first note is like in the script, in the execution, in the marketing, in the editing, they're always like, okay, we got to make sure she's likable. And I went to my husband one day and I was like, have you ever gotten the note where they like, we want to make sure this guy's likable? My husband's like, nobody's ever said that. And my husband plays deeply unlikable people, but you love him. And like women, they're like, they gotta be likable. And you're like, what is that? What does that even mean?
I was lucky to be able to be involved in so many different aspects of this movie, not just on screen. On screen is the smallest amount of work that I did in this film, to be honest. I took the relationships with my mother or my sisters or my children and my feelings, and I mean it's all over this film, and in ways that nobody will ever know, and I'll never tell anybody. But when I sit in that theater with my loved ones, they see themselves all over this film. Moments we've had together, things we've said to each other. And I think that's what I feel so proud, and it's so personal to me.
And I think that more than any movie I've ever done, like Lily is such a ball buster. I am rotten to the core when it comes to that. Like if I'm not busting your balls, then you should be worried. Then I'm mad at you. Then I don't love you. The way that I sort of use humor and levity in moments of sadness or pain, because that's the prism through which I can cope and deflect. I smile in sad moments because it's just how I process things. I'm not a person who has a lot of outward like rage or anger. Like I'll get upset about things, but I'm not yelly. I'm, quite even and patient. And so the way that I react to a situation, instead of doing like exactly what's on the page, if she's going to react this way, I may feel the exact same feeling, but I may not react the way that it's written that she reacts. And so I really tried to overlay the honesty of my heart and emotions onto Lily. And I think that that's why the performance is one that I'm very proud of, because
Hey friends, it's Katie from Without a Crystal Ball. Welcome back to my channel. It's Friday, February 28th, 2025. Listen, we've talked quite a bit about how people that are narcissistic misuse the court system and generally file motions and make requests that are outside of the norm, or try to get access to information that they don't otherwise need, simply because they can, because they want to intimidate the opposing party, they want to drive up costs. They really just want to use the court as a vehicle to cause more harm to their target. Frivolous litigation is super common, and Ryan and Blake Lively's lawsuit against Justin Baldoni is rooted in lies. A couple weeks ago, they issued subpoenas to communication companies like Verizon Wireless, AT&T, and T-Mobile, and they were seeking more than 2 years of phone records and trying to get access to the phone records of the parties that were involved in the lawsuit, third parties, and then literally anyone else that they might be able to access, so that they can figure out other people that are involved in this quote unquote smear campaign. And they were trying to get back 2 years to 2022. And Justin's team fought back, right? And they said that this is overbroad. This is going well beyond the scope of what's allowed in civil court. This is not a criminal case. And they have a right to privacy. And some of these timelines don't make sense. And the details that they want and the numbers they're seeking don't make sense. And they fought against it. And of course, Blake's team acted like them, Baldoni's attorneys, fighting them on this. They acted as though they had no business fighting against this. They acted like they had every right to seek this, and that Baldoni and Wayfarer and the other parties involved in this, are just trying to hide things and conceal things. And much like how the gag order request did not go in their way, the subpoena also did not go in their way. And I suspect the protective order will not go in their way. But there's nothing better in the world of the court when the narcissist loses and the judge can see through them. And today, Judge Liman ordered a motion to quash the subpoena. Part of it was granted, and the other part was denied. But the part that's denied is very small in the scope of things. What he said to Blake and what he said to Blake's side is what matters. And she got verbally smacked down by the judge. The judge was not happy, obviously. The fight over the subpoena has to do with how much information she wants and how intrusive this subpoena is, seeking documents and call logs and locations and going to places that are not allowed in civil court. The judge ordered a meet and confer so the parties, the two sides, could try to work things out. And this is how he describes it in the court order. After parties met and conferred, Lively agreed to remove the reference to all documents, remove the request for locational data, and clarify that the subpoenas seek only call logs and text logs reflecting non-content numerical information regarding ingoing and outgoing text messages. Lively has prepared and modified subpoenas reflecting these changes. However, by letter of February 24th, 2025, the Wayfarer parties reiterated their request to quash the subpoenas. The parties object to the fact that even as modified, the subpoenas continue to cover call and text logs, revealing the phone numbers for anyone with whom the Wayfarer parties and other individuals communicated, regardless of whether such communication was related to the claims and defenses in this case. The Wayfarer parties therefore seek to have the subpoenas limited to communications between the subpoenaed phone numbers and other specific phone numbers of parties and witnesses that Lively would provide. Now, Lively argues that the purpose of the subpoena lead to admissible evidence regarding communications not only among the defendants, but among the larger network of individuals who perpetuated the untraceable campaign against Miss Lively, which justifies their broad scope. Lively also argues that the Wayfarer parties lack standing to assert the privacy interests of non-parties. The judge uses Rule 26B1 of the Federal Rules of Civil Procedure as what he will use in order to make a determination on this motion. It says when the party moving to quash a subpoena is a non-recipient asserting a privacy interest, the court must weigh relevance or probative value of the documents being sought against the privacy interests asserted. And the burden of persuasion in a motion to quash a subpoena issued in the course of civil litigation is borne by the movant, and the movant is the person requesting. And so the order says this: the subpoenas of the Wayfarer parties' phone records, even as modified after the meet and confer, are overly intrusive and disproportionate to the needs of the case. The subpoenas request call and text logs between certain of the Wayfarer parties and any other phone number, in most cases from December 1st, 2022 to the present. This request implicates legitimate privacy interests. Even though Lively has narrowed her request to exclude the content of calls or messages, the phone records themselves would still contain sensitive information regarding which doctors, psychologists, or even acquaintances the Wayfarer parties spoke to and when. Lively has identified no means to segregate those numbers that may have some relevance to her case from those numbers that would have no relevance and would reveal sensitive personal information. Lively mainly argues that the subpoenas will help her identify the larger network of individuals who perpetuated a negative media campaign against her. And there's a footnote here which says, Lively notes that an individual has no legitimate privacy interest under the Fourth Amendment in numbers dialed on a phone. However, this does not prevent the Wayfarer parties from having a privacy interest in their phone records. A privacy interest which is not protected by the Fourth Amendment may nevertheless exist pursuant to a state or federal statute or the common law. The judge then cites the various common laws that would give him a right to privacy, even without the Fourth Amendment. And so therefore concludes that they have a privacy interest regardless of whether or not it's protected under the Fourth Amendment. Going back to the complaint, it says, but according to Lively's complaint, this negative campaign did not begin until approximately August 2024, describing actions taken in early August as the beginning of the plan to destroy Lively's reputation. It is therefore unclear how communications to and from Wayfarer parties in 2022 and 2023 would reveal individuals who participated in the campaign. More generally, Lively has not provided a basis to believe that the broad discovery she seeks will reveal information regarding unknown participants in the negative media campaign proportionate to the burden on the Wayfarer party's privacy interests. Lively's complaint already identifies many individuals who allegedly participated in a negative media campaign. Lively may make discovery requests tailored to those individuals. She is permitted to use the tools of discovery to identify the contact information or telephone numbers for those individuals. Even assuming additional individuals participated in the alleged campaign, the hope that discovery will turn up information on such participants does not justify the broad scope of the subpoenas. The subpoenas must be quashed to the extent they seek the phone records of Wayfarer parties. This ruling is without prejudice to the Lively party's service of modified subpoenas, more narrowly tailored to relevant information. So he's quashing the fact that she is seeking information from 2022 and 2023 because he says within the scope of the law, it's not permitted. And she can't use discovery to try to identify if this scheme came up before then because her own complaint states that she believes it started in August. So she can't go back before August. They're also saying that they can't use this to try to find other people that may or may not be involved. That's outside the scope of this. She can look at the phone records of the people she identifies and the third parties that she identifies, but she can't go beyond that because it's too broad and she doesn't have legal reasons for it and it will violate their privacy. So, what really he's saying here is that she has a chance to ask and subpoena within this very narrow context. She doesn't get to go back to 2022. She doesn't get to use this subpoena process to fish for records because, as Baldoni's lawyers argue, this is a fishing expedition. She's making a claim in the court, but she doesn't have the evidence. And so she's trying to get the evidence through the use of an abuse of subpoenas. So Baldoni's attorneys used the law to protect them and prevent her from abusing the court system and abusing the subpoenas. And she will have to create a modified subpoena within that very narrow scope. And the court is basically telling her, you have abused the court system by trying to get information that you're not entitled to, and your arguments are not valid and they are not within the scope of the law, and they're far too broad, and these people do have a right to privacy. And what I find interesting about their arguments with the privacy is that on the one hand, Blake says that they don't have a right to privacy when it comes to phone numbers. And she says that no one has a right to privacy, right? But then on the other hand, she says third parties and witnesses have a right to attorney's eyes only when it comes to discovery. So when it pertains to her, she wants privacy, but when it pertains to them, they don't get privacy. It's hypocritical. There's another footnote which says Lively has also suggested that the phone records may speak to when and how the defendants and witnesses learned about Miss Lively's harassment allegations, what type of information Lively seeks to discover in this regard, and how it is relevant to her claims has not been further explained. The ruling here is without prejudice to Lively's use of subpoenas targeted to reveal the particular information relevant to her claims of harassment and retaliation. So they're also saying she doesn't get to use subpoenas to try to determine when people figured out that she had made these allegations against Baldoni and Wayfarer because that's not a part of the lawsuit. She's really abusing the subpoena system, and his attorneys were right to fight this. Now, there's one aspect that the judge didn't quash, and it was related to third parties. And it says, however, the Wayfair parties have not demonstrated standing to object to the subpoena request seeking the phone records of non parties. A party demonstrates standing to challenge a subpoena directed to a non party by showing that he or she seeks to protect a personal privilege, right, or interest. The Wayfair parties may assert a privacy interest in their own phone records, but they have not provided any basis for asserting an interest in the communication of non parties. Therefore, the Wayfair motion is denied as to the portions of the subpoenas which seek the phone records of non parties. The motion to quash is granted in part and denied in part. So they aren't going to be able to quash the subpoenas for any non parties that are subpoenaed in this case. And what that means is she can still seek that information, but those non parties then could bring their own motion to quash. They just can't do it for themselves. So they can quash their own subpoenas, but they can't do it for the third parties that are not part of the case. They haven't, and they also didn't say that there was a privilege, like it's their spouse or their doctor or their psychologist. So, long story short, Baldoni's attorneys throughout this process have been very, I would say, aggressive. They're playing offensively, they're playing very strategically, and they're really up against a engine of Blake and Ryan that has a very large network of people and powerful people behind them that are trying to infiltrate and make the media believe that they're the victims here. And they're also trying to turn this into a political left and political right argument, which is truly unfair. This has nothing to do with politics. This is not a Me Too conversation. It's not a politically motivated conversation, but it's again a way for them to cause division. Because what I see now in the mainstream media are there's people that are on the left of politics and there's people on the right of politics. And the right are being accused of just going after Blake and Ryan because because they're liberal. And then liberal writers that work for whatever it's the New York Times or other outlets are trying to discredit anyone that is a Republican that doesn't like Blake and say that, well, they're just against her because they hate anyone in the Me Too movement. And you can't trust them. They're part of the smear campaign. So they're buying everything that Blake says and they're discounting everything that Justin says, not even taking into consideration what Justin went through, which is truly not the way that the media is supposed to report. If the media, like the New York Times, is going to take a side here and completely discount the point of view of Wayfair, they have done a disservice to the public. You can't just because a woman comes forward make it that this is a fact. There has to be some level of evidence. There has to be some sort of proof. And there also is an opportunity for the person that's being accused to defend themselves. And when you pick a side before you look at both sides, you are literally trying to sway the public opinion, which is why Baldoni is suing the New York Times, which it might be hard for him to win with the New York Times. It's very hard to win against newspapers and publications when it comes to defamation. It's very hard to prove malice. So it'll be more challenging on the respect of the New York Times. But the fact that they are able to make this a political issue when it's not is another way that they're speaking to trying to create division in the story. And quite honestly, it doesn't matter if you're on the left or the right. It doesn't matter if Blake and Ryan are liberals because so is Justin. They're both Democrats. So it's not a left and right issue. And just because a few right of the spectrum creators and podcasters like, say, Candace Owens are not on her side, that doesn't mean that Candace Owens is always wrong or is always evil or is always the enemy. The left journalists trying to make Candace the enemy because she doesn't believe Blake. And in a world of nuance, people are entitled to have opinions. So just like the New York Times is entitled to have an opinion, so is Candace. But the New York Times is not supposed to be based upon opinion. And whether or not they are aware, they are feeding into Blake's smear campaign of Justin. And whether they're just a puppet being puppeteered again by Blake and Ryan, it's clear that they were influenced by them and they're only seeing their side. They're refusing to look at the meat of Justin's case, which is completely a misservice to justice because there are two completely different sides here and there are two separate lawsuits. And so you can't just say that her lawsuit is truth and then say everything in his is false. Because if you say everything is in his is false, then you're ignoring all of the evidence that he has provided and you're not using the evidence he has provided to discount what's in her complaint. Because that's what the responsible journalist and individual that's looking at this would do, and so would a jury. Ultimately, all of us that are reporting on this are supposed to be looking at this from an objective point of view. We're supposed to be considering both sides. And objectively, if you see her side first, of course, it's the most powerful side. But if you don't take the time to know his side of the story or even give him an opportunity to show you why this isn't true or what evidence he has to refute it, and then you just go with it, that's the irresponsibility of what the Times is doing and any outlet that is trying to make this a Republican versus Democrat situation. Because I'm a Democrat and I'm definitely not on the side of Blake and Ryan. But you know what? Baldoni's a Democrat too. So you can't make this a right or a left thing. So it's not that all of us that are on Baldoni's side or that are even just being more in the middle and saying, this is what I see, and it's not in her favor, that it's not a political, it's looking at the facts. You don't get to make a decision on facts based on how you feel about someone. It's not personal. At the end of the day, her continued abuse of the process, the abuse of the subpoenas, the abuse of the protective orders, the overwhelming abuse of the media, and of using her power is the issue at hand. Now, that's not to say that Wayfarer is perfect, that the set was perfect, that mistakes didn't happen, that issues might not have occurred, but it's also not to say that they're evil and predators because she's provided no proof. And it's also not to say that there's even a smear campaign because what she has presented thus far doesn't prove a smear campaign. She's trying to say that because Perez Hilton's attorney on a defamation case that he won, it was Brian Friedman, that somehow now that's why that he's against Blake. But Perez is also just looking at what the facts are, right? And so because Candace Owens is a Republican, obviously you can't trust her, which what? I mean, whatever. And that's again a red herring argument. Maybe Candace gets some things wrong, maybe she gets some things right. I mean, politically speaking, it has nothing to do with how you view this case. And even Candace has said this case has really nothing to do with politics. It's the kind of case that actually can unite both sides because both sides are viewing this as a David and Goliath situation where someone very, very powerful is trying to squish the underdog. And most all of us want to fight for that underdog. And if the underdog has all kinds of evidence that show that what's happening to them that refutes it, and refutes it very obviously. And then you have insiders speaking to the Hollywood Reporter and Deadline saying that this is actually what happened. And insiders are actually saying that Sony was not on her side and they issued a statement for her saying that they would make 12 films for her because she was persuading them to do that. And by the way, the CEO that made that statement at Sony, he resigned. He left the company after, I think, 8 years. He was already on his way out when he made the statement. His removal or leaving the company had been in motion for 2 years. So, of course, when he makes a statement right before his departure, it's kind of irrelevant. He has nothing to lose. The same CEO also blamed the media for ruining his films because of reviews to the movies. So almost like Sony doesn't want to take responsibility for making a shitty movie, they blame the media for not liking it and causing their sales to go down. If you don't want critical reviews, make a good movie. If you don't want bad backlash for your marketing, be a better marketer. If you don't want consequences for your action, don't do the bad consequences. You know, my attorney in my defamation case said something in one of the filings which said, if you don't want to be reported on for doing or engaging in salacious or unflattering behavior, do not engage in the salacious and unflattering behavior. Do not blame the reporter, do not blame the media for reporting on the fact that you engaged in unflattering and salacious behavior. So here it's like Blake and Ryan, don't blame Justin and Wayfarer for your behavior, which was unflattering and offensive to people in the marketing campaign and dismissive. Don't put the blame and the backlash you're receiving because of your own behavior on Wayfarer and Justin. Because Justin's motive was always the same throughout. His way that he was going to market this film was how he ended up marketing the film. You're the ones that changed it in the 11th hour without consulting anyone. And that's on you because you missed the mark. The judge also is on to you and on to your abuse of the court system. And Justin and his team are slowly but surely dismantling the lawsuit that Lively filed against him. Let me know what your thoughts are in the comments below. Also, 60% of you on every one of my videos are not subscribed. Check to see if you're subscribed to make sure you're subscribed. Click the subscription button. It's completely free. Make sure to click the bell and turn it on so you get notifications for when I post. And I'm loving all of the comments. I'm loving to hear your thoughts. I love hearing from all of you, whether I agree or disagree. So tell me all of the things below. Thanks so much for watching. Bye, guys.